Hi, my name is Diana Goldstein, an associate in BLM's regulatory team. Partner Peter James and I are discussing fee for intervention. So, Peter, say I'm a director of a small manufacturing business. The company's had a visit from the Inspector of the Health and Safety Executive following an accident to one of our employees. I was told at the end of that meeting that the company would have to pay for a fee for the inspector's time. Is this correct?
Yes, this is called fee for intervention and came into effect on the 1st of October 2012. The Health and Safety and Nuclear Fees Regulations 2016 say a fee is payable to the HSE if an inspector is of the opinion that a person is in material breach of health and safety law and notifies that person in writing of that opinion.
Will a fee always be payable following a visit from the HSE?
No, duty holders who comply with health and safety laws and are not in material breach will not be charged.
The inspector mentioned the company was in material breach of the Health and Safety at Work Act and other regulations. He did not provide many details, but did say the company would have to take steps to resolve these issues. What is meant by material breach?
A material breach is a breach of health and safety law, which an inspector considers serious enough to have to write to the company requiring action to be taken to respond to that breach.
Will the HSE write to me setting this out?
Yes, an inspector will usually provide details of the breach and what you have to do to rectify this in a document called a notification of contravention. However, formal notice can also take the form of an improvement notice or prohibition notice, which require you to take steps to remedy health and safety breaches. The notification must set out the laws the inspector considers to have been broken, the reasons for that opinion, and that a fee is payable.
So the inspector was at our premises for about 3 hours. He spoke to a number of employees and asked for copies of some of our processes and procedures. How much is this going to cost the business?
The current rules allow the HSE to charge £154 per hour. This will include the costs of the visit and include the time it has taken for the inspector to identify the breach and help you rectify this. It can also include the inspector's time in completing reports, including the notification of contravention. It is possible the inspector will conduct further visits, take statements from employees and obtain an opinion from a specialist inspector, and this will also be chargeable.
But Peter, how can I check the time charged? And what if I'm unhappy with the inspector's decision?
You'll receive a separate invoice following the receipt of the notification of contravention setting out the time charged. This is payable in 30 days. The invoice will provide details of how to challenge that time charged. The first step is to issue a query to the FFI team. You can challenge the amount charged or the reason for the charges, and you must do so in 21 days. The query may be upheld, partially upheld, or refused. The fees charged may be reduced if it's considered they were not incurred in establishing the relevant breach or putting this right.
What happens if I'm unhappy with that decision? If the fees are inspected by the HSE, how is this independent?
If you're unhappy with the result of the query, you can raise a dispute. You have 21 days to do this after the query is resolved. There is a charge for the dispute if it is unsuccessful. The dispute will be considered by a disputes panel independent of the HSE.
So Peter, what should I do next? We have practices and procedures in place to ensure work can be carried out safely. The injured person made a mistake. I'm not sure whether our company is in breach.
You should expect to receive a notification of contravention shortly. It's important to set out clearly if you do not accept the inspector's opinion concerning material breach or wish to reserve the company's position if you're unsure on that point.
Thank you for listening to our podcast. We hope you found it helpful. BLM can assist with the response to the notification of contravention, appealing improvement and prohibition notices, and with queries and disputes. The time permitted for responding is limited and will only be extended in exceptional circumstances. We advise duty holders to obtain legal advice as soon as they are told a fee is payable or an inspector serves an improvement or prohibition notice to allow sufficient time for challenge.